Hello and welcome. Before we begin, we would like you to take a few minutes to test your knowledge and see how familiar you are with some key components of developing a sound IEP. Feel free to change or adjust your answers as we move through the information.
Hi, I'm Haley Anechka, and I'm presenting today with my colleague, Arlene Gonzalez. As school law attorneys, Arlene and I have reviewed hundreds of IEPs. We have seen the good, the bad, and the what the heck. But more importantly, Arlene and I are both former educators in public schools in Texas, and we understand the time and resource constraints often placed on teachers, service providers, and administrators. We hope our presentation will help you understand the basics of creating a legally sound IEP. Because of time, we couldn't go over everything that needs to be included in an IEP, but we chose to focus on the areas that we as lawyers see the most issues with. The first step to developing an IEP your lawyer would be proud of is understanding the legal standards that a hearing officer will apply. In 1975, the Education for All Handicapped Children Act was passed. This was a funding statute which meant that if schools would provide a free, appropriate public education to children with disabilities, schools could get federal money. Raleigh was the first case to define what FAPE was and went all the way to the United States Supreme Court, so that decision affected all schools in the United States. It held that a basic floor of education opportunity does not mean best education. It means appropriate. But there were different standards for appropriate, and each appellate court came up with their own standard. 35 years later, the Supreme Court again looked at what FAPE is. The 10th Circuit had determined that reasonably calculated to enable a student to receive educational benefit meant that the benefit was barely more than de minimis. Really, just a tiny bit more than no benefit at all would be enough for FAPE in the 10th Circuit. The Supreme Court said, nope, that's not good enough for FAPE. It must be reasonably calculated to enable the child to make progress appropriate in light of the child's circumstances. Key language: must individualize to the child. Really analyze the child's circumstances to develop a plan calculated for the child to make progress in light of that child's unique needs. 10 years before Andrew F., our appellate court, the 5th Circuit, had wrestled with what it means to have an IEP reasonably calculated to confer educational benefit. In the Michael F. case, the court applied a 4-factor test which has become the standard for determining if an IEP is reasonably calculated to confer educational benefit. The 4 factors are: is the program individualized on the basis of the student's assessment and performance? The program is administered in the least restrictive environment. The services are provided in a coordinated and collaborative manner by the key stakeholders, and positive academic and non-academic benefits are demonstrated. Key stakeholders include parents, teachers, paraprofessionals, related service providers, behavior specialists, and so on. After Andrew F., Advocates were eager to get a case to the Fifth Circuit because they claimed that Andrew F. overturned the Michael F. standard. ER versus Spring Branch ISD was the first case where the Fifth Circuit clearly stated that the standards laid out in Michael F. met the Andrew F. standard for FAPE. So in the Richardson case, this is where the court kind of held that you don't have to consider or weigh the Michael F. factors in any particular way or in any particular order, but depending on the facts of the case, the court may look at and give one factor more weight than others. So nowhere in Raleigh is the educational benefit defined exclusively or even primarily in terms of correcting the child's disability, but the whole educational experience and its adaptation to confer benefits on the child is the ultimate goal, a holistic approach. Overall educational benefit, not solely disability remediation, is IDEA's statutory goal.
Now let's look at how to have a productive IEP team meeting that results in a complete and clear IEP. Before going to law school and becoming an attorney, I was a teacher and administrator. I participated in many ARDs and remember how important it was that we keep our meetings productive. We also wanted to make sure that not only was this the best plan for this individual student, but that it was written in a way that was clear and easy to understand, so our teachers in school could effectively implement the plan. To have a good productive meeting, consider these steps to prepare. Staff and communicate before the ARD meeting and provide information to parents before the ARD. Reviewing new evaluations with parents and giving parents previews of major changes are important steps in having an ARD that reaches consensus. Sending home draft goals is not required, but it's generally a good idea, and we recommend it when there's an advocate involved because it saves time for everyone in the meeting. We see another important step is to gather real evidence of progress goals. I feel that this is so important. There needs to be real evidence of progress on goals and objectives that have been in place. These goals have to be measurable. There has to be some kind of data collection to be able to show progress on goals and objectives, whether they're academic, behavioral, or even social skills. This type of system for collecting the data doesn't really matter. What matters is that the data is accurate and the teacher implements it. Remember those Michael F. factors Haley described earlier? One of those factors was positive academic and non-academic benefits are demonstrated. Well, data is a way to show this. If I were to call you to testify in a due process hearing, how would you prove that the student made progress? Now, remember in preparing for an ARD meeting, you don't want to engage in predetermination. To quickly review, predetermination is when school members of the IEP team have decided on a program and/or placement prior to the ARD committee meeting without parent participation or input. This can be a serious issue because it significantly impedes on the parent's right to meaningful participation and can amount to the denial of FAPE. We don't want that. But this doesn't mean you can't prepare suggestions. It just means that you have to be open to parents' input. Now, let's touch on what predetermination is not. I know one thing that may have crossed your mind. I know it crossed my mind when I was an assistant principal, are draft IEPs. Draft IEPs are not necessarily predetermination, but they're more of a starting point for the discussion that will take place at the ARD. It's important to remember that districts must make clear to parents that the services proposed in these draft IEPs are only recommendations for review and discussion with the parents. Many of you may have participated in a staffing before. A staffing prior to an ARD committee meeting doesn't necessarily show predetermination. But again, team members must enter the IEP team meeting with an open mind and must really consider the parents' input. Let's take a look at this example of predetermination. In this Gregory Portland ISD case, a district refused to consider or even discuss the use of ABA for a student with autism, despite a clear indication of progress using ABA. Predetermination not to consider ABA violated the student's right to FAPE. A refusal to discuss or even consider what a parent suggests can be seen as predetermination. I want to review what evidence of predetermination can look like. The first example is emails. Emails can be a big deal in due process hearings, even if the emails are only between staff. An example of an email showing predetermination can sound something like this. We know mom is going to disagree, but we're going to change Joe's placement to resource anyway. Remember, emails become part of discovery in due process hearings. Other examples of evidence of predetermination are statements made in staffings prior to the IEP team meeting, statements to parents, any directives that are given to staff, and even statements made in the IEP team meeting itself. Here are some important actions to take to avoid a finding of predetermination. Whatever proposals are provided before the ARD should be accompanied by an email or a letter that says that these are proposals that the ARD committee will consider, and these proposals may be accepted, amended, or eliminated, and something else agreed to will take its place. This same rule applies for draft ARD documents. More actions to take are participate with an open mind, continually seek parent input, adjust proposed IEPs as appropriate to reflect parent suggestions, and meaningfully consider parent input. Also, make sure that the deliberations or minutes reflect the fact that you considered parent input and you took all of these actions. Now, let's talk about notice. You can't have an ARD without proper notice. Of course, we have to provide notice to the parent to have an ARD meeting. Make sure your notice states the purpose, time, and location. You also have to send written notice even when the meeting has been set out by agreement. Now let's look at this next point here. Notice must be received, not just sent, but received 5 school days before the meeting. The IDEA sets out specifically who the participants in an ARD meeting shall be. Essential members include the parent, the regular education teacher, the special education teacher. I'd like to make a quick note here that one person cannot serve the dual roles of being both the regular and special education teacher. You need to have 2 different teachers in these roles. I just wanted to make that quick note. You also have to have a school representative and a person who can interpret instructional implication of evaluation. This can be someone who's already participating in another role, though. It's important that the district take the appropriate steps to ensure parents are present and given the opportunity to participate. Timely notice and agreeing to a time and place are the first steps in making sure parents can participate. Keep in mind that the district has a duty to provide interpreters, not the parents. It's not up to the parents to bring their own interpreter, but instead, the district has a responsibility to know when an interpreter is needed and to provide one. It's also important that the interpreter be knowledgeable enough with the ARD and IEP process to communicate effectively with parents. Sometimes the parent just can't make the meeting and we can't get a response back. It happens. You can have a meeting without the parent, but documentation is very important here. You will need to show attempts in contacting the parent and how you worked with them to find a meeting time that worked with their schedule. I listed earlier all of the essential members of the IEP team. It's important that the correct teachers are present at the ARD meetings. There should be at least one regular teacher of the child if the child is or may be participating in the regular education environment. If the student's in all general ed classes, then you can use a related service provider, a co-teacher, or a case manager. When it comes to the representative of the school district, there are a few requirements to meet. The IDEA uses 4 factors to determine who qualifies as a representative of the school district. You must make sure that the representative is qualified to provide or supervise provision of the special ed instruction, that they are knowledgeable about the general curriculum, they are knowledgeable about the availability of resources in the district, and that they can commit district resources. For this last factor, if an unexpected demand is made, let's say like private placement, and you're unsure about what you can or you cannot commit to, don't say, we can't make this decision. Instead, say, we will need more information to make this decision, and let's call a recess. Examples of who can be a representative of the school can be a principal, an assistant principal, a special ed coordinator, or an ARD coordinator. At the ARD committee meeting, it's important that someone can interpret the assessment data. It doesn't have to be a diagnostician, but it usually is. It's also important to ensure the participation of other individuals who may be needed. Every ARD meeting is unique, and there may be others who are required to participate. Knowing when additional members are needed can be based on the child's disability. The student's disability will determine what related service providers are necessary. The parent can also invite other members. The school can also ask others to participate who have special expertise and can provide valuable information to the meeting. Here's some information of when and how a member may be excused from a meeting. Parents and the school district may jointly excuse an IEP team member from attending the meeting if the service or curricular area will not be discussed. Even if the service or curricular area will be discussed, the parents in a district may excuse the excused member, but that excused member must provide written input to the IEP team. The agreement must be in writing and include the parent consent. Video conference and conference call meetings are permitted if agreed upon. Looking at some policy and practice implications, it's important to consider what the ARD notice needs to say about attendees. The school district must clearly designate staff members who have the authority to enter into agreements with parents to excuse members. Also, ensure that parents truly understand and voluntarily agree to excusing an IEP team member. Another important policy and practice implication is when the district representative is excused, that position must be filled. The person filling the position must also have the authority to commit school district resources that I explained earlier. Consider calling a recess and reconvening if it's an unanticipated service area that's raised at the meeting and a relevant team member has been excused from attendance. The first few minutes can really set the tone for the rest of the meeting. Here are 4 to-dos that can make the meeting more productive. First, do identify consensus members. These include the essential members we discussed: the parent, the general education teacher, the special education teacher, the representative of the district, and someone who can interpret assessments and evaluations. The agenda will let the parent and advocate know how we're going to move through the meeting and will let them know the appropriate time to raise their concerns about matters. Along with the agenda, establish ground rules. Also, very important, listen to parents' issues. Let the parent know at what point in the process those issues are going to be discussed. This can help frustration and stress levels and help keep them both low. One of the first things the ARD committee will do is review the PLAF, the present levels of academic achievement and functional performance. Remember those 4 Michael F. factors again. The review of the PLAF is basis for factor number 1 under Michael F., which Does anyone remember what that is? It's the IEP is individualized on the basis of the student's current assessment and performance. And remember the Supreme Court case, Andrew F. The IEP is calculated to enable the student to make progress appropriate in light of the student's circumstances. The PLAF is part of defining those circumstances. During the meeting, it's always a good thing to at least mention behavior, even if behavior may not be an issue. If it's not an issue, say that in the meeting. If behavior is an issue, then it should be addressed in the IEP through a behavior intervention plan. Now, here's a list of things not to do during the meeting. Do not ask anyone to sign who was not there. If you held the ARD without a required person, do it over. I know that's not something you want to hear, but do not ever ask anyone to falsify a record. Do not let consensus members or decision makers leave before the ARD is over. If a consensus member has to leave, recess the ARD. Do not set artificial time limits, but it is okay to set goals at the beginning, such as we are available for 2 hours today. If we don't finish in those 2 hours, we will recess and reconvene at a mutually agreeable time. That's okay. Do not stop because there is disagreement. Finish the agenda. Your ARD minutes should be noting areas of disagreement as you go along, but try to get to the end. Stopping because disagreement looks like you're not willing to work with the parent. And the last point, do not force staff to agree. This leaves you open to a predetermination claim. And as we talked about earlier, we definitely don't want that because it can look like it could result as a denial of faith. Moving on to things you need to do. Listening to parents is very important. I know I just said this before, and I will say it again. Listen to the parents. The ARD process can be very confusing and intimidating. Continually seek to engage parents and make sure they understand that their questions are being answered. A parent who feels like they're being heard and truly feel like they're part of the process can make all the difference. Now let's talk about accommodations. Please, for your teacher's sake, the team needs to put a lot of thought into the accommodations and make sure it's very clear what the accommodations are and when they should be implemented. I remember this so well when I was a teacher. I would look at my list of accommodations and run into certain accommodations and not know what they mean. I'm a big rule follower and I didn't want to get in trouble, so I agonized over implementing some of these accommodations, even simple ones like extended time. I thought, what does this mean exactly? Does extended time apply to every assignment or just major exams? What about quizzes? Do quizzes count as an exam or as an assignment? How much time is extended time? Don't do this to your teachers. Also, please do not write as needed without clarification. My view of as needed can be different than your view of needed, and you can bet that it's going to be different than the parent's understanding of as needed. When there's a dispute, the parent is always going to say that it was needed. Do not check modifications for every class. If you really think about it, do you really need to reduce written assignments for the PE class? Don't check each one of last year's modifications without individualizing to current needs. Like I said before, always go back to the data, update, and have discussions. Finally, do not check only because the parent requests it. Instead, this is a good time to have a discussion with the parent and listen to why they are requesting the accommodation. You may have learned something that you didn't know before, or you can suggest a different or even a better accommodation. The parent can learn something from you, and they can walk out seeing things a little differently. Remember, it's all about listening to one another, checking for understanding, and asking questions. Related services. This is usually less of an issue because you have specific recommendations to ARD from related service providers, but make sure the schedule is clear in the IEP. It should include the date to begin services, the duration, frequency, location, and who will be providing these services. Minutes. Minutes are not required by the IDEA, but they are critical to being able to defend an IEP in a due process hearing. The minutes don't have to be verbatim like a court reporter would write them, but just make sure to capture the gist of the discussions. For example, if a parent brings up a concern, make sure that this is captured in the discussions. Also, even more important, make sure to write in the school's response to the parent's concern in the minutes and the deliberations. There's a New York case where the minutes saved the district from being found to have denied the student FAPE. The minutes provide the story behind the IEP. It explains why things are the way they are. In that New York case, it saved the day. They're very critical in helping staff prepare for a hearing. It's a great memory jogger. Imagine having to remember what was said and what was done in a meeting from 2 to 3 years ago. I also want to highlight one of the points here. Do take time to reread and correct. I have found that our committees who do this produce some of the best minutes. It will not only save you a lot of time at the end to make them more accurate, and when editing grammatical errors, but you remember things better when you do this. And the best part is that when you have everyone in the room, the best part is that you still have everyone in the room in case you need to ask clarifying questions. Let's move to the end of the IEP meeting. The goal, of course, is to have the parent and the school agree. Remember, though, that it's not a majority vote. If consensus is not reached, then offer a one-time 10-day school recess. Make sure to send notice of this. The team will reconvene in 10 school days unless an alternate date was agreed upon by all the parties. Parents do have the option to say, no, I don't want a recess. If that happens, then the ARD ends in disagreement. A recess is not required where a student has committed an expellable or DAP offense, or when their presence on campus presents a danger of physical harm to the student or to others. It's also important to know the difference between a recess when needed for timing or for gathering information versus a 10 school day recess when there's non-consensus. When the IEP team reconvenes, there's no need to redo the whole ARD meeting. Instead, focus on the issues of disagreement and work through those. If consensus is reached, then great. If not, then the district implements the IEP it has determined to be appropriate 5 school days after providing the parent prior written notice. Remember, this is 5 days after providing the prior written notice. Include a written statement of the basis for disagreement in the IEP. This should be reflected in the minutes as well as a prior written notice. And offer the parent the opportunity to write their own statement of disagreement. As we can all see, virtual IEP team meetings are here to stay. Whether you love them or you hate them, all legal requirements stay the same. Proper notice is required, as we discussed earlier. Identify the reason for convening virtually or by telephone, and make sure the notice contains the issues that are going to be discussed. After the IEP meeting, I mentioned earlier about providing prior written notice. Make sure that it's clear, correct, and detailed. You can complete prior written notice at the ARD if it's simple and everyone agrees, or you can complete after the ARD so you have time to do it in detail. Send it to the parent as soon as it's complete. Parents must have prior written notice 5 school days before implementing the IEP. When implementing an IEP, make sure that there is some system in place that tracks that each teacher has received the IEP.
Now let's take a closer look at the development of the IEP. What does the IDEA say about what has to be in the IEP? The IEP must include a statement of measurable annual goals, including academic and functional goals, designed to meet the child's needs that result from the child's disability to enable the child to be involved in and make progress in the general education curriculum and meet each of the child's other educational needs that result from the child's disability. One administrative law judge suggested that a well-written IEP goal would pass the stranger test. Under that test, an IEP goal is appropriate if a person unfamiliar with the IEP would be able to implement the goal, implement the assessment of the student's progress on the goal, and determine whether the student's progress was satisfactory. So that's how you can tell if your goal is measurable. Would a stranger off the street be able to read it and determine whether this child had made progress or not? The IDEA requires that every IEP include a description of how the child's progress toward meeting the annual goals will be measured and when periodic reports on the progress the child is making toward meeting those goals will be provided. This is how the IDEA defines a PLAF. It's a statement of the child's present levels of academic achievement and functional performance, including how the child's disability affects the child's involvement and progress in the general education curriculum, and for preschool children, as appropriate, how the disability affects the child's participation in appropriate activities. So while using test scores is not always appropriate, test scores accompanied by some individual analysis is common in developing the PLAFs. In the City of Chicago case, the district's reliance on generalized statements to describe the student's present levels of performance rather than objective, measurable data was insufficient to meet the standard laid out in the regulations, since it would not permit the district to track his progress toward his goals. The social emotional goal stated for the student stated that the student would improve his social skills by responding to social interaction with minimal assistance once a week. The correspondence statements regarding the student's present level of performance stated that the student was very shy in social situations and has difficulty expressing his ideas in front of peers. The other present levels of performance were written in similarly generalized terms. None included objective, measurable data. The hearing officer found that the district failed to provide the student FAPE and ordered the district pay the prior year's tuition at a private school for the student. These are just a group of cases that show what we've talked about, that if you don't have PLAFs that really are measurable, that and aren't clearly stated, then you can't really prove that you've been providing FAPE. Documentations of performance on goals needs to be easy to implement because the teacher charged with implementation probably has multiple other responsibilities. It needs to be steady and a reasonable number of times per week. You need to report progress as often as progress is reported to parents of non-disabled students, and in some situations, you're going to report progress even more. So when you have good, accurate data, it's going to help you develop good PLAFs, which will help you develop good, measurable goals, which will help you have an appropriate IEP. Another requirement under the IDEA is placement in the least restrictive environment. Considerations are, is the student educated at the home campus? They're not removed from the general education classroom solely because they need modifications, and other harmful effects on the student or on the quality of service. You consider the continuum of alternate placements required, which range from least to very restrictive. and participation to the maximum extent appropriate with non-disabled students. This includes meals, recess, counseling, athletics. It is just one component of FAPE. As stated in Andrew F., the IDEA requires an educational program reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. One that is appropriately ambitious. The appropriateness of an IEP, remember again in the Fifth Circuit, we apply the 4-factor test from Michael F., and the least restrictive environment is one of those 4 factors. The Daniel RR is the case that hearing officers in Texas used to analyze an IEP in a case where least restrictive environment is the issue. It's a 2-part inquiry. Can education in the regular classroom with the use of supplemental aids and services be achieved satisfactorily? If not, has the school mainstreamed the child in other parts of the school day to the maximum amount appropriate? So the second part of the inquiry is where things like lunch, recess, what some districts call specials, art, music, and PE come into play. When you're developing the least restrictive environment, one thing you want to consider is have you made adequate efforts to provide supplemental aids and services? When you're modifying the curriculum, have you modified it beyond recognition? Now, is the student in the general education classroom, but they are doing basically a whole separate class because the curriculum has been modified so much. Look at the academic and non-academic benefits, the overall educational experience, and the effect on the classroom. Can the student receive benefit in some academic classes, if not all of them? I recently had a case where the student really struggled in math, science, and math, reading, and writing, but did really well in science and social studies because of, at the elementary level, the setup of the science and social studies class and his particular disabilities, he was able to function really well in them. So he did reading, writing, and math in a more of a resource type setting, but participated successfully in science and social studies in the general education setting. The Richardson ISD versus Michael Z case looked at whether a residential placement is appropriate. So you look at, is that placement essential in order for the student to receive a meaningful educational benefit, and is it primarily oriented toward enabling the child to receive an education? So what if you have a 10-year-old boy, he's AU, ID, SI, he's been in general education with in-class support and a resource room support. The campus then proposes a self-contained special education class for ELA, math, science, and social studies for the next school year. So if you break it down, in the student's current placement, he's had decreased disruptive behaviors, which he had before, but now those behaviors have decreased. He has increased independence, increased compliance, and increased initiative, and he's had meaningful educational progress on his IEPs. The proposed placement is at a low academic level. The student would have access to curriculum at his level and pace, and access to non-disabled peers during non-academic times of the day. The proposed placement does include students with behavioral problems similar to those the student previously exhibited, but which had decreased in the general education setting. So the court held that this proposed placement was not LRE. Below grade level performance alone will not justify removal from a general education classroom. It's important to look at the student's individual progress. He may be behind his peers, but if he is making consistent progress, the general education setting may still be the least restrictive environment. So Daniel RR makes it clear that a student's effect on the class must also be considered. Is the student disruptive to other students in the class, or does the student take up so much time and attention from the teacher that the teacher is not able to give the rest of the class proper attention. Let's look at this case. You have an 11-year-old girl, extreme behavioral outburst. The parents' history of enrolling, re-enrolling. So she was in a 3rd grade classroom, general education, with 20 minutes per day of special education. You had significant behavioral incidents. You'll see some of the things there. There was a lot worse that we just did not include in this PowerPoint. You had other parents demanding that their children be removed from that class because they were concerned about their child's safety around this student. The teacher had rearranged seating, rearranged the room, reduced classwork, reward system. None of that worked. So then the ARD committee proposed new goals and 4 hours per day in special education. The parent said no and transferred the student. Terrible behavior continued. The school did an FBA, proposed new goals, and still 4 hours a day of special education. The parent refused. Due process hearing was filed, went to federal court. The parent said, well, my child was in step 1 and you're wanting to move them to step 3. We should do step 2. The court held that the regulations do not require that a child has to fail in the least restrictive options on the continuum before that child can be placed in a setting that is appropriate to his or her needs. In this situation, the student posed a danger to classmates, hit, spit, groped, pulled hair, pushed students down, threw scissors. Parents were calling the school, wanting their students removed from that class. Some children were so anxious about being in class with a student that they would spend their day in the counselor's office. The teacher had tried different methodologies. None of them worked. The court held that the 4 hours a day of special education was necessary for the student to make progress on her goals. 3 hours per day, she would still be in activities with non-disabled students. So this placement, the placement that the school district was proposing, was the appropriate LRE. So in order to make good, least restrictive environment decisions, number one thing, it is individual case-by-case determination. Consider the PLAF. Again, data. Look at the data. What does the data show? Consider what supplemental aids and services would be helpful to the student to be successful in the general education classroom. Remember Daniel RR. Whether the district has made reasonable efforts to mainstream the child, educational benefits available in general education class with supplemental aids and services, and possible negative effects on other children and also on the student himself. I had a recent case with a sweet boy who was just so behind his peers and knew it that he would just shut down because he knew what he was doing was so different from what they were doing. And as we just saw with our case, the placement where failure will obviously occur is not required. You can move them past the next step on the continuum. Are there some general education core classes that would be least restrictive environment but not others? Can the child participate in other parts of the school day, such as recess and lunch? And don't assume that the placement will stay the same year to year.
Now, last but not least, but definitely the part I consider to be one of the most important parts of the IEP meeting, considering the human side of the IEP team meeting. One of the best ways we can empathize with one another is to put yourself in the parent's position. Even when we know we're doing all that we can for a student we care for very much, students will lash out at us even if they know the child is wrong or that our response is actually very appropriate. At the end of the day, parents want respect for themselves and their children. Administrative convenience is usually not perceived by the parents as a good reason for anything. Parents showing concern for their children is a natural human reaction, and they will feel better if they see that you share the same concern for their child. The ARD process is a very intimidating process. Keep in mind that we do this every single day, so it may not be that daunting to us anymore. Many of these parents only experience this once a year, if that. There are also parents who are intimidated by teachers and principals, and may be reluctant to raise issues of their own. Some parents may never realize that their view of their child is incorrect, and there's never going to be anything that you can ever say or do that will change that. As we've mentioned several times in this presentation, communication is key to this very collaborative process. Be approachable and accessible. Remember to return phone calls and to respond to emails in a timely manner. Avoid technical language when possible. I know sometimes that technical language is necessary, but make sure to follow up and explain the language or the process in plain and simple terms. Always ask open-ended questions, and most importantly, listen. Before we go, let's review the answers to the questions you answered at the very beginning of our presentation. Number 1, true or false? Providing a special education student with FAPE means providing the best education. This answer is false. Providing a special education student with FAPE means providing an appropriate education. Remember, Haley reviewed this at the beginning. The Supreme Court clarified that the IEP must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. Question number 2. What are the 4 factors Texas courts look at to determine if an IEP is reasonably calculated to confer an educational benefit? For this question, we look to the Michael F. factors. Those factors are, number 1, the program is individualized on the basis of the student's assessment and performance. Number 2, the program is administered in the least restrictive environment. Number 3, the services are provided in a coordinated and collaborative manner by the key stakeholders. And number 4, positive academic and non-academic benefits are demonstrated. Question number 3. An email among school staff stating, "We know mom is going to disagree, but we're going to change Joe's placement to resource anyway," is an example of A, staffing, B, collaboration among the ARD committee, C, predetermination, or D, evidence of providing FAPE. The answer to question 3 is C, predetermination. This is a clear example of when school members of an IEP team meeting have decided on a program or placement prior to the ARD without parent participation or input. Also, remember that emails like this become part of discovery in due process hearings, so always be mindful of what you're writing in emails. Question number 4. Circle 1. The regulations do or do not require that a student has to fail in the least restrictive options on the continuum before that child can be placed in a setting that is appropriate to his or her needs. The answer to number 4 is the regulations do not require that a child has to fail in the least restrictive options on the continuum before that child can be placed in a setting that is appropriate for his or her needs. Remember when we discussed the case IL versus Knox County Board of Education? The court quoted the U.S. Department of Education commentary to federal regulations stating that this was not required.
Thank you all so much for attending our presentation today. Please let us know if you have any questions. Our emails are included on the end of this PowerPoint. Feel free to email us with any questions. Thank you.